morning, everyone, and welcome to our webinar this morning. We are going to be talking about essential estate planning, protecting your family and your assets. And so we wanted to take a moment to welcome everybody. It's just now about 10 o'clock. So hopefully we're going to have a few more people joining us, but thank you to all of you for being on time with us this morning. Wanted to go over a few basics before we introduce our speaker and get started. The format for today is we are going to have Valerie here speak for about 30 minutes, telling us everything we need to know about estate planning. And then after that, we're going to open it up for questions and answers. So if you came into this today with some questions on your mind, I encourage you to jot those down. Hopefully Valerie will cover some of those things. If not, or if questions come to mind during the presentation, just write it down. We'll try to take those at the end. And obviously, if we don't get a chance to cover everything, you can send me those questions and we'll try to get those questions answered for you. So the goal today is in about 45 minutes to have the presentation and handle the question and answers. So thank you again for joining us. When we do the question and answers, I will have you raise your hand. So on the bottom of your screen, there should be a section called reactions. And if you click on that, there should be an option to raise your hand. So when we get to that, I'll remind you, but just look for that at the bottom. You'll be able to unmute yourself, raise your hand, and ask a question. Okay, with that being said, let me introduce our fabulous speaker for today. Her name is Valerie Passion. I mean, how is that for a name? That's fantastic. And she's definitely passionate about what she does and what she's here to share with us today. She is an estate planning attorney and partner, and she's a partner at the Asset Protection and Elder Law Center in Irvine, California. She is a local gal. She graduated summa cum laude from the University of California, Irvine. And she's also an alumni from the UCLA School of Law. Okay, so we've got a very bright one here with us today. Not only is she great at what she does professionally, but she is married with 4 children at home, so she's constantly balancing the challenges of her professional life and home life at home. And so we are very fortunate and lucky to have her with us today. She is deeply committed to providing exceptional legal guidance and helping clients secure their life and navigate the complexities of asset protection and elder law. So she's here to share with us, like I said, not only the basics, talk about some of the documents, talk about some of what's changing with estate planning, and also answer some of your questions. So with that, I'm going to let Valerie get started. And Valerie, thank you so much for giving your time today and being with us. And I'm going to let you take it from here.
Thank you so much, Megan. And yes, estate planning. I know a lot of you guys here are thinking, wow, that sounds about as exciting as watching grass grow. Well, I assure you, I will keep it light. I will keep it fun. Like Megan said, I'm a mom of 4. If I did not keep things fun, my kids would never listen to me. So I promise you, not only will it be light and fun, but it will be very informative. I'm going to go over the foundational stuff about estate planning, things that really 90% of the population should be aware of. I'll also touch on some, recent changing laws in estate planning. But most importantly, I want to make sure that I can answer some of your questions, because at the end of the day, estate planning is about people, and you guys are Megan's people. So that's what I want to do. When we're thinking about estate planning, I want you to think of me and Megan really as a team. So here Megan is, we are in, the cockpit together. We are flying this plane. And Megan's really responsible for making sure that she flies that right path so that she can build your assets while you're still alive and living and enjoying your life. My job really is I take in when we're going to land that plane. Okay. And we're trying to land it so that it lands safely to the right people, to the people that you trust, and to keep you safe. So that's kind of my job. So if we are good with that, I am actually going to share my slide. All right, so this is a picture of my greatest assets. This is my family. And it's funny because every time I present this picture, there's always some wise guy in the back saying, that's not assets, that's liabilities. I assure you, a family is my greatest asset. This is really why I do what I do. I have 4 kids. They are all still minors. So I'm very familiar with working with young parents that have young kids because I understand the issues and the problems and the mindset that they have. This is my husband, Roland. He's also my high school sweetheart, like Megan said. He is a huge Laker fan. We do have season tickets to the Lakers. I enjoy my time with my husband. I am not a huge basketball fan. Forgive me, guys, but I am a fan of my husband. So I try to support him and do the things that he loves. And then last but not least, this is my youngest and my only daughter, Olivia. Interesting story, actually. When I was preparing the slides for you guys today, my boys, jokingly made a comment, why does Olivia get her own picture? And I told them, the truth is, she's the favorite. No, I'm just kidding. They all love her. She's really the jewel of their eye. And as much as, her dad and I love her and spoil her, her brothers spoil her even more. So they understand. All right, now let's begin the interesting stuff. So what is estate planning? So estate planning can be described in a lot of different ways. There are a series of legal documents. It's your wishes in writing. There are specific documents involved, but I like to say that your estate planning is really your love letter to your family. It allows you to tell a story of what you want your roadmap to be. And then it also allows the rest of the world to hear and understand that this is what you want. And it opens the doors for your family to make life a whole lot easier for them. It allows you to plan for life after you pass. The reality is it's going to happen. I hate to say it. There's, nothing sure in life except death and taxes, but it also allows you to plan things for your life while you're still living. And so that's kind of why estate planning is so important. I'm going to kind of go over the foundational documents in an estate plan. I really want you to feel empowered with that knowledge. I'm not just going to come in here and say, oh, you need to have an attorney, you need to do this, you need to do that. I really want you to understand the logistics of a basic plan. Now, the most important document that most people are going to have is going to be called a trust, a revocable living trust. Now, this document allows you to designate who gets what at your passing. Not only can you designate who gets what, but it also allows you to designate how your family receives those assets. Now, that's a very important component, especially if you're like me and you have, young minor children. That how component is very, very important. But I would say that the most important reason why most people want to get a revocable living trust plan in place is to avoid the dreaded probate. Now, probate is a court process that your assets go through if there is no estate planning or beneficiary designation on your assets. And it's also not, the funnest thing to go through. There are 3 important reasons why we want our families to avoid probate at all costs. First and foremost, it is extremely expensive. When you open up a case in probate, it's about $3,000 in fees just to open up the case. And this is before it even goes through the court process. Then there are administration fees. It's generally a percentage of the market value of your assets. Okay. If you really break it down, it's about 4 to 5%. So let me give you some practical examples of that. Let's say you bought a house in Orange County and you bought it for $500,000, but at time of death, that house is worth $1 million. That's pretty common here in Orange County. That's also pretty conservative. Well, that's about $20,000 to $30,000 in probate fees. And this is even before the case gets settled. So not only is it expensive, but it is also very time consuming. So probate takes anywhere between a year to a year and a half in court. And that is pretty standard. During the pandemic, it was so backlogged. Most cases were going 2 years. So you can see that that's definitely not something you want to put your loved ones through, the time commitment, as well as it is public. Anytime a case comes into probate, it becomes public record. Anyone can kind of see it. That's why we always hear about, celebrities and, who inherited what, what's going on. I mean, a couple examples are Prince, there was Michael Jackson. One of the recent ones was Chaz Baldworth. He was the Black Panther person. It turns out he didn't have an estate plan, and his family actually ended up paying $1.5 million in fees. So, I mean, I know most of you guys are thinking, well, I'm not a celebrity, that doesn't really pertain to me. Well, you also have to think about it like this, when things are public, anyone can look into the records and kind of see who's inheriting what. And in our world where things are getting progressively scarier, there's a lot of con artists out there. There's a lot of people out there who are seeking these opportunities. Our job is to really make sure that we protect our family from all of that, from, the public, from potential creditors, and even from themselves. The next document that I want to go over is the will. Kind of like the trust, the will allows you to designate who gets what at your passing. But unlike the will, it does not avoid probate. Usually when someone has real property in California, a will is not going to be sufficient. However, it is good for someone who has very simple assets. They don't own real property. This allows them to designate who gets what. They don't really have the component of how things get designated, and it doesn't avoid probate. So keep that in mind. That's kind of what separates a trust and a will. But when you have a revocable trust, you still have a will, but it's going to be called a pour over will. The pour over will, once again, it allows your assets to be handled by your executor. It allows them to handle things that are outside of your name. But the most important component about the pour over will is that essentially it allows your executor to transfer anything that should be in the trust that isn't in the trust back into the trust. So if you imagine the trust like a bucket, you need to make sure that your assets go into that bucket. In the event that for whatever reason your asset is not in the bucket, your pour over will allow your executor to say, hey, wait a minute, I know that the grantor meant for this to go in the bucket. So with my power as an executor, I'm putting it back into the bucket for them. So they're sort of like a scoop for you. An example of that is, let's say, you buy a vacation house and for whatever reason, it is not designated in your trust. Well, essentially you could have the most beautifully drafted trust, but if that asset is not in the trust, it's going to go through probate. So that's really where that pour over will comes into play. Very important document. But as like a mom of four, I would say that the most important thing that the will allows is that this is where your guardian designation lies. Your guardian designation allows you to designate who gets to step in and take care of your children in the event that you and your spouse are unable to do so. For me, this was the most important document. This was also the most difficult question for my husband and I, but only because we realized that if we did not have this in place, a judge who did not know us would decide who's going to be raising our children. And we all know people who look great on paper that we just don't want raising our children. So for us, this was probably the most important decision for our family, was the guardian designation. Now, these documents, the trusts, the will, they really only come into play once you pass. However, there are a few documents that are going to be important right now while you're still alive, because at the end of the day, we are still living in this world and still requiring us to do important things. So the first is called the power of attorney. This document allows your agent to essentially step into your shoes and manage all your financial decisions for you in the event that you are unable to do so. I will say that during the pandemic, this document really became the star of the show, because not only does it help you when you are incapacitated or unable to step in, but let's say, you're traveling abroad and a pandemic hits and they're closing all airports and no one's flying in or out of the country. Well, guess what? This happened to my aunt. She was actually stuck in Asia for 6 months, unplanned, not expecting to stay that long. However, she had a niece who prepared for her and made sure that my sister-in-law could step in the event that, something like this happened. My sister-in-law was able to pull out money from her account, send it over to her in Asia. My aunt was also in the process of selling her house in Cyprus. My sister got to step in and kind of make sure that transaction, finished. So she was very, very thankful that I thought about the possible what ifs for her. So this is the financial power of attorney for finances. Next, it's the healthcare documents. Now, our firm, these documents are very important for our firm. We actually have 3 documents in particular that we always provide for our clients. The first is called the HIPAA authorization. Essentially, this document allows, your agent to receive medical information on your behalf. This also allows them to request medical information for you. Very important document, because without this document in place, physicians, hospital, medical institutions are just not going to talk to them. I had a client come in also kind of around the pandemic time. He said he went into the doctor's office for a routine checkup. And the doctor said, you have COVID. I'm going to send you straight to the hospital. During his transition to the hospital, he kind of lost the ability to give verbal authorization to allow his family to speak for him. For a month straight, he was stuck in the hospital. His 3 children who lived out of state were calling the facility every single day for over a month, asking what was wrong with their dad. All the doctor said to him was, I'm sorry, we cannot talk to you and you cannot come and visit. You can imagine how livid my client was when he found out about this. Once he started feeling better, he came to us and said, Val, the most important document for me is going to be that HIPAA authorization. I never, ever want to put my children through that mess ever again. So very important document. The next document is going to be called the Advanced Healthcare Directive. This document allows your agent to step into your shoes, kind of like the financial power of attorney, but instead of financial decisions, they can make healthcare decisions for you in the event that you can't, of course. And then last but not least, it's your living will. This document allows your agent to make that very important decision of whether to keep you or take you off of life support in the event that you need that decision. Now, keep in mind, without these documents in place, once again, your loved ones will have to go to a judge who does not know you, request authorization to do something that they already know you want. But in this situation, it's going to take a whole lot longer, and it's going to cost a pretty penny too. I had a client come in requesting this for his sister. He said that the attorney charged him $25,000 before it even went to court. So as you can see, by preemptively putting these documents in place ahead of time, you save your family a lot of time, money, stress, than them having to deal with it on the back end of things. There are a bit more documents as well that is included in what I'd like to call, a basic estate plan. However, for simplicity reasons, these are really the main documents, and this is really what 90% of the population needs. Statistics are not favorable. About 90% of the population needs some sort of estate planning, whether it be a trust or a will or a power of attorney. The reality is only about 30% have any planning at all. And within that 30%, a lot of it is very insufficient planning, whether it be that they tried doing it themselves, or maybe they used their cousin who's an attorney that only handles immigration law. Whatever reason, there are a lot of insufficient plans out there. And that is one of the reasons I see that our probate court tends to be pretty backlogged. So when we are doing our plan, it is really not a one size fit all type of model. It's very important to make sure that you are talking to your attorney and making sure that you have all the adequate documents that you and your family need in order to ensure that you have a sufficient plan. All right, our next slide. Who needs an estate plan? Well, spoiler alert, everyone. As you mentioned, estate planning isn't just for the ultra wealthy, or those that are ready to pass on. It really is for anyone, but there are certain people in particular that I think it is even more important for. So basically, anyone who owns real property, unmarried couples, this is also one way to ensure that your loved ones and people that are important to you can jump in and make decisions for you. People with minor children, people with blended families, anyone with assets over $197,000, business owners, divorced people, and parents of all kinds. Because just because our kids have grown up and moved out of the house does not mean that we still don't want to take care of them. High net worth individuals, these are people that should really consider, talking to an attorney and making sure that they have a plan in place. All right. So this is where I kind of want to discuss, some of the updates and some of the things that are going on in estate planning. This is going to be a bit more informal. And also I will allow for questions towards the end. All right. So let's go over some of the updates that we have in 2025. So one thing that is going on right now is that the small estate affidavit limit has increased. Okay, so what is the small estate affidavit? In simple terms, it's sort of like if probate is like the DMV, it's sort of like a DMV pass, okay? It allows for certain people to bypass that probate line and have a more simplified process. Now, basically, this is people that have assets under a certain threshold. For 2025, it is $196,000. Okay, this is actually up from last year, which was $187,000. So anyone that has over this amount should really consider having a revocable living trust, because the small estate affidavit will not help in that matters. But why does this matter to a lot of Californians? Well, now, people can kind of do things that are faster, cheaper, out of the court process. And even for people who have a trust, this is beneficial because sometimes things fall out of the trust. And so we want to make sure that there are some things that will allow, smaller assets to get transferred without the tedious probate process. Another change that was made recently is that the changes to gifts to minors. So it used to be that if you had a custodian account for a minor, by 18, they would be able to receive it all. And there was nothing that you could do about it. And this was actually quite scary for a lot of people, because if we all remember being 18, we all remember that we were not the greatest when it came to finances. Statistics say something along the lines of, most people who inherit unearned money or receive unearned money, they spend it within 2 years, whether it's $2 or $2 million. So this is something that's quite beneficial. It has changed it so that you can change any of these custodial accounts to now 25. I think it's better, but I still don't think it's ideal. With the trust, you do get a lot more control over how those young children inherit assets. For me, for example, my young children, I have a staggered approach. They don't inherit, they inherit one half at 25, one half at 30, and the remainder at 35. I feel that I like to have a little bit more control, because when you have a trust, it's more about protecting them from themselves. So that although the 25 change is a lot better, it is still not exactly ideal. But it works. Another change, and I think this is a very important change, is the access to digital assets. So this is a big one, because now more and more we are seeing that a lot of people have a lot of IP online, whether that be, digital currency, maybe they have a media company, maybe, even something as simple as a Facebook account. There was a lot of unsaid rules. There were a lot of things that were changing in this world, but recently they just allowed that when you have a document that states specifically that your executor can step in, they can now manage these digital assets, and institutions cannot be against this, which is huge for us, because I think majority of us, most of our assets are online now. And so I think it's very important that if a big part of your portfolio or a big part of your life lies on digital world, that you talk to an attorney and figure out how you can kind of get this document set for you. Okay. Great update to the law. And then last but not least, I would say that this is probably the most important thing that people want to hear. So right now, California has no estate tax. So that's great. However, there is the federal exemption for estate tax, and that is right now in 2025, they increased it. It is $13.61 million per person. So if you have under this amount, you don't have to worry too much about, estate taxes on the federal level. If you are married, you can combine it, so the amount is even more. So most people, I would say 90% of the population, don't really think much about this. However, in 2026, it is still on the table that amount may cut significantly, up to 50%. So if you kind of fall into the threshold of, hey, you know what, I don't have $13 million, but I, have, $6 million, $7 million, I'm getting to that amount. I think at that point, it's very important that you talk to an attorney to see how you can work it so that it is in your best favor. Okay. So these are some of the updates that I, kind of wanted to bring up. Obviously, there's a lot more than that, but I wanted to highlight the more important ones for you guys all. And now I'm done with my presentation. I hope that was very helpful. I'm going to open things up and see if anybody has any questions.
Yeah. Valerie, thank you so much. That was fantastic. And I think so many of us, by the way, I love your analogy about the plane. I think that you can visualize that and really understand that. And I do think there's so much of what we do where we need to work together, where, we're help people manage their assets, but all those other components of planning, we do all the financial planning, and the estate planning piece is part of that. And so making sure we're working with your estate planning attorneys, that we know your estate planning attorneys. And I think one of the things, I know you said that you were going to make this fun. And I think most people sometimes they don't think of financial planning and estate planning as fun, but I do think you did a great job of explaining it, and also letting people understand how important it is. And in a lot of your stories, it was somebody who experienced something and then realized they didn't have the right planning in place. And I think one of the big reasons of doing these webinars and having these conversations is to understand the importance of doing this and planning in advance, right? And making sure that you understand what these important documents do, that you have these on file so that the circumstances that you can't plan for. You didn't know the global pandemic was going to happen, right? You didn't know that you were going to fall ill and at this time, right? Everybody always thinks they have more time. And if there's anything we could encourage you to do is to do estate planning now, right? Start that planning. You can always change your wishes over time, but how do you feel about things today based on current law? Put that in writing, and then it's something that you update over time. So
Yeah. Yeah.
that's a
Well, thank you
question
for
I was
sharing that.
I
Yeah.
was just
And
going to
I
say
do
that's
want
a
to say, guys, I'm
yeah.
gonna, interrupt Megan a little bit because you have a fantastic financial planner. So I want you guys to first give her a high five for setting these webinars up for you, because information is power. Because at the end of the day, if you don't want Megan or I flying your plane, it's good to have that information because, who knows, maybe you want to learn how to fly that plane. But whatever the reason, I think having someone who's preemptively sharing this information is fantastic. So please reach out to Megan and just thank her for all she does. This is not easy.
Thank you, Valerie. That was very sweet. And also, I do want to make sure anybody who's on the call here today who doesn't have an estate planner, right? Or who isn't happy with their estate planner, we can make those connections, we can make introductions, and we can be part of those conversations, and we should be part of those conversations. So please don't hesitate to reach out for those purposes. So I have a question for you, Valerie, and then
Yeah.
we'll open it up to questions from everybody else. So when you have a relationship with a client and you understand their situation, you do their basic documents of what they need, how often do you recommend that is reviewed or updated?
Great question, Megan. So I actually recommend 3 to 5 years. I think that is enough time where things have changed and you don't even realize how much has changed. So something that our firm actually provides for our existing clients is that every 3 years they get a trust review meeting, and it's completely, complimentary. It's just part of the planning where I sit down, I review the trust from beginning to end and just make sure that everything is still valid, that it's, updated to all the necessary California laws. So I think 3 to 5 years is a good time. However, there are times where that time will be cut short. So if there are major life changes in your event, such as, a divorce or a death in the family or a change in, beneficiary, something big like that, that is another reason to kind of get your plan reviewed.
Good. Yeah, I think that's important. I'm thinking everybody who's sitting here who has an estate plan start to think about when was the last time I updated that? When was the last time I looked at that? Or I got a better one for you. Is my estate planning attorney still alive? Are they still in business? Right? Do I have a copy of my estate plan? Right? These are some of the things
Yeah.
that we hear and we see. So these are good things. And obviously, if you're on this call, you probably know the answers to those questions. It's the people that aren't on this call that we need to worry about. But one last question for you. I know a common estate planning mistake that I see is people setting up the trust, but then not what we call funding the trust or putting
Oh,
assets in the name of the trust. So I was going to say, is that what you see too? And maybe expound on that a little bit about what does it mean to fund the trust, and how do you make sure that once you meet with your estate planner and do these things, how do you need to make sure that you're finishing the process?
fantastic question again, Megan. So funding is probably one of the most important things that any of my clients can do. So funding is when you title assets from your name into the trust. Our firm really emphasizes this part. If anything, we may overemphasize this part, but we actually handle all the big funding for our clients. So when it comes to important things like real property, businesses, LLCs, S corps, like we make sure that we fund all those assets for our clients. Okay, because I think those are the more important ones. And then we give very detailed instructions on the things that we can't handle, such as, how they need to talk to their financial advisor, how they need to update, beneficiaries, to the trust. Like we give very comprehensive instructions. Not only do we have a funding meeting that is in person, we also provide an instruction booklet for our clients so that they can review on their own, as well as we do something that most, attorneys don't even want to think about, but we do provide unlimited guidance to our clients, and we don't charge an hourly rate for this. So anytime our clients have a funding issue about any new assets that they're acquiring or any existing assets they have, they can always call us, email us, send us a text even, and we guide them through this process. Because we find that it is so important. And I find that it's one of the biggest reasons why plans are insufficient, because you can have the most beautifully drafted trust, but if things are not funded properly, it's as if you don't have a trust at all. And I will say, 9 out of 8 times when a plan is, when I'm reviewing a plan and someone tried doing it themselves, on like an online platform, or maybe they used an attorney that doesn't really specialize in estate planning, something is not funded.
Yes, I can't emphasize this enough how huge this is. Number one, the service you provide in doing this, but that whole idea of funding, of what that really means is making sure your asset is titled correctly in the name of the trust, right? Is the deed to your home in the name of your trust?
Yes.
Is your investment account in the name of your trust, right? And do you have beneficiary designations on your retirement assets, right? What should those look like? These are things that we work on. We work with your estate planner on. But again, doing the documents is wonderful and is the first step and is hugely important. But making sure that then they're funded and titled in the trust makes sure you're finishing the job. So I was just going to say,
Yeah,
in all the
absolutely.
years of doing this, and so it's important to make sure you're working with someone who sees that through process through to the end, and something that we obviously look at on our end as well. So I realize I just asked all the questions and you guys are supposed to be the ones answering or asking questions. So I'm going to be quiet for a minute and go ahead again. At the bottom of your screen, there's the react button. You can look and you can raise your hand and ask a question if you have one. Okay, it looks like I see Lorna. I see your hand is raised. And if you can go ahead on and unmute yourself, you should see the audio icon there. Beautiful. Okay, Lorna,
Okay.
you're up.
Hi, Lorna.
Hello. I am one of Megan and
Henley.
thank you, Tenley. And when I get nervous, I forget names. That's the first thing I forget always.
Don't be nervous.
I
We're
am
all
one of
family
those
here.
troublesome clients. I have about 4 questions, so you can stop me after each one. Some of them are just clarifications. The first one I wrote down was, do I understand correctly that if I had something written down in my will, it is subject to probate? However, if I have it written in my will, but also written in my trust, then it would not be subject to probate. Is that correct?
Good question. So yes, the difference between a trust and a will is that assets that are designated by the trust can avoid the probate process. Assets that are distributed through the will still go through probate, but really it depends on the asset, Lorna. Not everything necessarily will go through probate. It just sort of depends on the asset. But the big picture is yes, the trust allows us to avoid that, tedious court process. A will does not. Okay. If you want to be more specific, I can kind of help guide you as well.
Oh, well, my thought would just be is avoid putting stuff in your will and just put everything in your trust. Wouldn't that be the simplest?
Yeah, absolutely. Okay. Yeah. And that's why a lot of my clients, even if they don't think they necessarily need a trust, maybe they feel like, hey, I just have, a simple estate. Most of my clients want to have that trust because they just want to avoid, the idea of anything going through probate. Let me give you an example.
Right.
We had
I've got it. To me, that's the answer to my question, because you guys know, I'm a very simple person, is put very little in my will. Okay, fine. Next question I had is just a clarification. Did I understand you correctly to say that there is no California estate tax?
Yeah, that's one of the one of
Okay.
the few tax advantages is that we have in California is that there is no California estate tax. Now, please do not quote me on this because 5 years down the line, if someone on the higher ups decides that that's going to change,
Well, and I don't think it's going to take 5 years because we're not a favorite of the higher
so
ups.
so
Okay,
just
fine.
always, yeah, keep your ears open. Right now, that's one of the best benefits that we as California
Okay.
residents
So,
do
but
have.
then the federal estate tax, would you remind me what you said of that? Because it
Yeah,
takes a while
so
for my brain to work.
we don't have estate tax in the federal level unless our estate is above $13.61 million per person. If you're married, you can essentially double that amount.
Okay, not a
However,
problem for me.
however, in 2026, it is slated to cut to about half. So if
Oh,
anyone, you or is kind of at that threshold, it's definitely time to consult with their attorney and see what they could do.
so you're thinking it may be reduced to about 7 million?
That is what is on the books right now. However, anything can change. We live
Okay,
in a very
okay.
fragile legal world right now.
Yeah, we do. Now, have I used up your time for doing this? Megan, please tell me. Tenley, please tell me.
No, if you have one more question, go ahead, and then we'll open it up for someone else to ask a question.
And please jump in if I'm taking too much time. Okay, I'm going to give you the umbrella. The umbrella is I have 3 adult children. I have 2 adult grandchildren and 3 minor grandchildren. So my question has to do with leaving or the beneficiaries. So for 2 of my children who are married, longtime married, I would prefer to leave. I am going to make their mates the beneficiaries. Okay. The more troublesome one is my 3rd child, who is divorced, who has a minor child, and in no way do I want his wife, who's quite lovely, but she would not be a good person to manage my grandchild's money in case my son dies. So my plan is to have one of my other sons be a custodian of his account and then measure it out as he might need it for college, whatever. And with that 25, perhaps, and my other son is pretty good at investing. Okay, so that's one plan. The other one, I have no doubt at all that the money that I might be able to leave to my kids would go to my son and his wife in case that son should die. Okay. The next one is my daughter, who is married, who has a mate, longtime marriage, who is owing $200,000 on student loans. He is not real good with money, and he's a bit of a procrastinator. And she has alerted me to the fact that she doesn't want me, if I have the ability, to pay his loan off right away. She said, I get nothing out of this. I had to stop school so he could go on, blah, blah, blah. Here's the question. How often, or is it appropriate for that particular part of my family to make my daughter the beneficiary, and in the absence of my daughter, should she die, divide into 3 husband and 2 adult children the benefits that might have gone to her? That's that question.
Yeah,
Another hour on this one. I'm so sorry. Please understand.
no, I
I'll
think
back out.
this
Megan
one
and Kenley, control this time.
I think that this question in particular is a little bit more nuanced, and it's very important to sit down with your attorney and kind of go through it one by one. But in a general answer, yes. And that is why a trust is so important, because we actually can allow certain people that we want to inherit, certain beneficiaries we want to still inherit, but still protect them, potentially protect them from, creditor claims or ex-spouses, or from themselves. There's a lot of language, there's a lot of things that we can actually draft in the trust that can, allow you to address every single issue that you talked about. I would love to kind of, sit down and kind of go over, individually each person and how it should be addressed. Due to time, I could kind of give you that blanket answer is that yes, absolutely. You should leave it to whoever you want to inherit it, but please keep some parameters around it. And that is why a trust is so beautiful, because you can add those parameters.
Okay,
Yeah.
that's what I'm
And I
working
think,
on right now. And Megan, you were going to say something important.
yeah, well, I was just going to say, so Lorna, we can probably continue this conversation because I do want to make sure we have an opportunity for someone else to ask a question.
Please.
But I
Sure.
think what
I apologize to everybody else.
No, you're good. And I think that's the point though, is those wishes and treating your children differently because their marriages are different and their dynamics are different, and all of that can be accomplished. And those, as long as you understand what your wishes are, the trust can make those things happen. And it's okay to do that, right? It's okay to treat them differently, or structure things differently based on what you know about their character and what your desires are. So I think that's probably the key piece of that. So, but Lorna, we can definitely pick this up and continue that conversation. So with that though, because of time, is there anybody else that would like to raise their hand and ask a question of Valerie? Oh, David. It looks like we've got David on the line.
I am.
David,
Hi.
Hi, David.
I
what
have
questions do you have for us today?
two brief questions. One, a pour over will. Is that a separate legal document from a general will, or can it be included as a paragraph in the general will?
Good question. It should be a separate document. It should very clearly state that it is a pour over will. There is specific language in a pour over will that is not necessarily in a standard will. So if you do have a standard will, and there are, things written in there that kind of state that it has like the pour over powers, then you should be good. But there is specific language that needs to be in there, and not all wills are pour over wills. So that's a very good question.
Okay. The other question has to do with the access to digital assets.
Yeah.
As this is something new, is this something that you would recommend amending your trust to include, or is this something that should be a separate document?
So if you have significant assets that are digital assets, I think a separate document is the most ideal way to go. Because at the end of the day, our job as attorneys is to be as clear as we possibly can. There are trusts out there that kind of highlight, maybe they do highlight that digital assets are something that, your, trustee can manage or your executor can manage. But I like the idea that if there is a significant amount of digital assets, to actually have a separate document kind of clarifying that, you want to make sure you have an agent that can manage these assets.
Thank you.
Thank you.
Yes,
Great
and
questions.
to further answer your question, yes, just go back to your attorney. It does not have to be like a full restatement. It's just going to be an add-on document to your plan.
Okay.
Okay. Great questions, David.
Thank you,
Megan.
David.
Oh, all right. It looks like we have a question from Janet. Perfect. And you're off mute. Okay, fire away.
Hi, Janet.
Hi, how are you?
I'm good.
Good. Okay, well, I did do a trust about 20 years ago, got divorced, redid my trust. Since then, Megan knows this, a couple months ago, I sold my property in California. My children are now adults, so there's so many changes that I need to make in my trust. The biggest one is I live in Florida now.
Okay.
So that being said, laws are different here. I know that. Do I need to make amendments to the trust that I have, or just do a whole new trust? And is that something you can help me with, or do I need to find an attorney here?
So good question. I recommend to meet with an attorney in Florida. The reality is probate law is different from state to state. And it's very important that you have someone who is very familiar with Florida law. Now, we do have an attorney that is licensed in Florida, but we feel that we wouldn't be doing our California, clients a service if we also focused on, Florida law, because we want to be just experts at California law. So I
Okay.
want you to find an expert in Florida law that can help you. As much as I want to help everyone, I also know that we want to do a good job. And so I recommend meeting with a Florida lawyer. For the most part, I think that your California trust may still be applicable in certain cases. However, you just have to, it's better to be safe than sorry, and,
Yeah.
meet with that person and see if it needs to be updated.
Okay. And then can I have my children, like they're going to be the beneficiaries? Can I make them one of the trustees to handle that? I mean,
Oh yeah,
yeah. Okay.
absolutely. As long as it's a child that you trust, that
Right.
can handle things well, that is probably one of the most common nominations that I see is an adult child.
Yeah.
Yeah.
Okay. Well, if either one of you can refer me someone here in Florida, I need to get on this. And I guess the last question I have is, I am 25% owner of a property here that is under an LLC. So I should put that into the trust as well.
Yeah. So a document that would be needed for that would be called an assignment of LLC. So I would just make sure that your attorney adds that assignment to your plan in order to make sure that your business does not go through probate.
Okay. Got it.
Okay,
Okay.
awesome. Janet, thank you for joining us, and thank you for
Thank
the good
you.
questions.
Thank you, Janet.
All right, anybody else have any questions for Valerie? All right, looks like Gwen, you are up. Go ahead and take yourself off mute. And okay, there we go.
Hi,
Thank you so
Gwen.
much. Hi. So a couple of things. One, and I had to step away for a call for a minute, so I don't know if I missed it. Sorry if I'm repeating this, but just a reminder to make sure that your insurance policy includes your trust as one of the covered individuals. Mine did not. And of course, after all the fires and everything, I heard horror stories and I checked. And of course, it was not in the trust, although my home is in the trust. So potentially, I guess there could have been an issue with the insurer not covering my home because it was not, because the trust wasn't named. Second is what I learned the hard way is if you do inherit money, tell your beneficiaries about this, your children. Do not necessarily put it into pay off community debt, or don't track it because it will become community property very quickly and they will lose half of it. So it is important to make sure that they are securing your, their legacy and making sure that it's protected, worst case scenario, but just to make sure that that's protected. And then, Valerie, do you have a basic price for trust and your services or trust creation? I
Yeah,
have mine
great
redone.
question. So first off, thank you for sharing that input. You actually hit the nail on the head. It's very important that we name the trust as an additional insured entity on any sort of insurance policy. That used to not always be the case. It used to be just sort of assumed that if you were listed by name on your insurance, that anything in your trust would be there. But like you said, with the rapid amount of wildfires and so much coverage that these insurance companies had to pay, they started to get very nitpicky all of a sudden. And I actually got firsthand knowledge from one of the insurance brokers that I work with that never before did he ever have to deal with situations like that. But, after, having to pay so much damages, they became extremely nitpicky. So it's always better to be safe than sorry. I also agree about your point about, making sure that your beneficiaries are very smart about how they handle any sort of inheritance. I actually used to be a family law attorney, so that's another world, another life. But it does give me a very good grasp of how important it is to segregate community property versus separate property, and how to manage your estate in order to take these differences into account. So this is always something that I guide my clients on. And I always say that I will guide their family as well, giving them that peace of mind that, their beneficiaries are not going to be affected in that way. And last but not least, pricing. So our firm actually works on a flat fee. Our prices start at $2,000 for a will plan, but it sort of includes, all our documents, our lifetime guidance, we do things from A to Z, and I can always give you guys a list of everything that is included. Our single revocable living trust plans start at $4,500. And then our marital plans start at $5,500, and this is an all-inclusive price. Obviously, these are just sort of general price markers, but I do kind of need to see more of the specifics and more of the unique circumstances to give like a better price point. But I hope that helps.
Thank you. It
Perfect.
does.
Yeah, no, thank you. And also, just to put this in perspective, to spend a few $1,000s, whether it's 2, 4, 5, whatever, to make sure that you have your estate planning done to save you, in probate, you'll get that back in your quality of sleep, and obviously the planning and that you're doing, and the money that you're saving yourself. So obviously the value is there when it's done correctly. So maybe we'll take one last question if we have it. I can't see if there's any more hands. So one more round to see anybody who didn't get a chance to ask a question yet. And this is when I love it, which means Valerie, you nailed it. We've answered all questions, either that or everyone else had to get back to work, or
well, you had wonderful clients with wonderful questions. And I just want to add one more point to what Megan said. Thank you, by the way, for allowing me to come and share. I may be a little biased, but I don't necessarily think that we are going to be the cheapest firm out there. I also don't think that we are the most expensive. I do like to think that we are the most valuable, just based on everything that we provide our clients. But at the end of the day, I'm really not here to sell anyone here. I genuinely love what I do. I genuinely want to share. I think that it's better that you get anything done than necessarily have to get it done with me. I just want to make sure that your families are protected. Like I said, I'm a mom of 4, and my family is my greatest assets. And so I'm just very passionate that people go out there and get themselves protected.
Okay. Yeah. Valerie Passion is passionate. Wonderful. We got it. We won't forget that. So everybody, thank you so much for joining us. Valerie, thank you so much for sharing your expertise, your time.
Megan.
And thank you to all the people who are on this call. I always say this is recorded. And so we'll have the replays available so you can hear this again, share it with your friends, share it with your family. And we're always here as a resource for you to talk about not only your wealth management, your financial planning, obviously, but the estate planning and how that fits into everything. So thank you so much for joining us today. We really appreciate it. Again, Valerie, thank you so much again for your time. Again, any questions, please don't hesitate to reach out to us, and we can always connect you with Valerie directly as well. Okay.
Well, thank you. And thank you to your team, Bryant and Julia. They were great as well. And I really appreciate you inviting me to come on here. I feel honored.
You bet. You bet. Thank you, everybody. Have a great day. Have a great week. All right.
All right. Bye, guys.
Thank you.